But first, a message from our sponsor. IACT membership is very important so that we can go out and buy this inappropriate level of audiovisual technology and put it up on the web and distribute it via local access. These sorts of things don't come cheap, even though we buy them at Walmart. And it turns out there are other benefits for membership. Some of those benefits include these very fancy name tags. You can also get parking decals, which you can put on your windows. Yes, there's one. It's upside down, but it will come right side up. And security won't ostensibly give you a ticket. And if they do, I will appeal it successfully so far in every case. If you do get a ticket and you don't have a sticker and you're not a member, it's a $50 ticket. And membership is only $45. So it pays for itself in just one ticket. There's every reason to expect that you should be able to park once you have a parking sticker. And once they clear the construction, parking will be easier. Our next meeting will probably be up the hill, and I'll have detailed directions for everybody so that we don't have to deal with this construction, which is a nuisance. So there's this aspect of the construction which was supposed to be all finished by now, and I believed them when they told me that. But I'm gullible that way. I believe what people tell me. And I'll probably continue to do that. But for next time, for sure, we'll be somewhere else, not here. Unless all the construction goes away magically by August. There is going to be another meeting in August, in case anyone's wondering. So, for intros, Chad, you want to?
My name is Chad Lyons. I'm a third-generation inventor. My business is called Quantum Leap Technology, and it basically is a marketing vehicle for an advanced acoustic pocket that works with, complements a advanced adhered acoustic sensor for medical purposes. What we can do is get really high fidelity sounds from inside the body at a very low cost. So I view this as enabling when looking at widespread use. I've been a member, 4 years?
I'm Tom Heafy from Torrington. I've been a member about a year. Have one invention that's patent pending, and in the meantime I'm doing my day job, which is sales in New York.
Sales of what?
Hardware and tools. Hardware and tools.
I'm Chris Heafy. I'm his brother. I have an ongoing interest in inventing.
My name is Pedro Cabrera. I am a mechanical engineer with Sikorsky Aircraft. I've been with the Rotor Systems Group for about 10 years now, and doing both design and more recently structure analysis.
Hi, my name is Ned Gannon. This is my first meeting. I'm working with a small team of engineers on an aftermarket device for the hybrid electric and electric vehicles.
My name is Tom Freund. This is my first meeting also. I'm basically a consultant who deals with monitoring and diagnostics and control of infrastructure equipment. That could be for a data center, could be for a building, dwelling, etc.
I'm John Bromer. It's my first meeting. I just found out about it a couple days ago, and I thought it was at 7 o'clock. But obviously everybody knows something I don't. And I'm a building contractor by trade.
It does start at 7.
And I have not signed up.
Oh. We'll get you a sign-in sheet. I think it's floating around somewhere.
That's what
Here it is.
Michael Knight, CPA in Fairfield, Connecticut. I want all you guys to be successful, so you need all my good tax advice. And the guy, of course, my son's a mechanical engineer at Northeastern, so maybe you can get him a job when he gets out.
I'm a bookkeeper, owner and founder of IACTrick, key inventor from Brantford, Connecticut, in the area of electrical and thermal conductors.
I'm Fredo. I'm a geophysicist working in according to geology, mainly
interested, so I'm just curious. And
Glad she's interested in participatory in model Congress meetings, so she's been on, what's committee?
it doesn't really matter.
Just like a high school kid.
Oh, sorry.
John Yankovich, patent attorney. I've been a member for a few months now, and my background is in electrical engineering and computer science.
We should get you a proper name.
I may have one. I'm a member.
Okay.
I signed up to do
have it in
that.
a file somewhere.
Oh, you have a name tag also somewhere?
I created
Well,
one.
you created one, but there should be one like this for people who have paid, I think.
I don't think I paid yet.
Oh.
Name tag for you.
My name is Pat Waller. I have two utility patents and 5 provisional patents. A couple of the utility patents I've already lost. And I'm a visitor tonight. I'm not a member.
That's all right.
You're allowed.
It's permitted.
Hi, Michael Svensson. Sounds like we're doing quick blurbs. I have a patent I let expire, and I have another patent in process. I consult on emerging technologies, particularly in the renewable energy space.
I'm Gary Van Dersen. I own a company with the catch name of Van Dersen LLC. Do innovation and design for clients all over the world. Actually. I used to be the corporate vice president of innovation and design for Stanley Tools, Black & Decker, DeWalt. That was before, actually, for those companies separate. Ironically, they're together now.
Okay.
And Coleman Outdoor Products.
I'm Russ Lowry. I'm an experimental helicopter test pilot. And when I'm not doing that, I'm also known as the business owner's financial advisor. That's my specialty for owners of privately held companies.
I'm Ed Shuffett, Senior Electronic Engineer. The last title I had anyhow. I had a company with 80 people and did stuff that went with the Macintosh until they stopped selling very well. And now I'm doing stuff for the iPad and the iPhone, a electronic project.
We missed a couple people that came in.
My name is Sean Harris. I'm from Stratford. I'm here. I also let a patent expire. I'm looking for some guidance on how to either obtain it or some kind of resolution to my problem, and which is in working on ice cream novelties.
Did you say ice cream?
Yeah, novelty, yeah.
Oh, okay.
He just became my favorite guy.
I'm Justin Kreutzer. I'm interested in optical consulting, precision engineering. I have a number of patents that belong to my previous employer at ASML.
And did somebody else just walk in? Did you just walk in? Yes. Okay.
Hi, I'm Fred Paulman. I'm a management consultant. I work a lot with intellectual property, and I'm glad to learn more about the topic.
I'm here too as a visitor to learn about the subject.
That leaves us just one.
And who else just walked in? Ah, yes.
Jason Liu. I'm with General Network Service Inc. in Stamford, Connecticut. I involve quite a lot of innovation and commercialization of innovation. I was a scientist at Bell Laboratory and a technical director for ITD in my younger days.
At Bell?
Bell, yes.
Wow. I was at Bell as well.
Yes, I know.
In my younger days. There's a sign-up sheet going around for those who just arrived. So
Hey,
let's
Doug.
see. Yes.
Who's he?
Don?
And I'm Don.
Did you not
For us,
introduce
for us
yourself?
visitors, we don't know who Don is.
I'm Don Ellingham. Been probably the longest member of the group, I think, maybe 12 or 13 years. I am a membership chairman, so if you want to join, talk to me. or go to our website, inventus.org, and right on the front page there's a place to join or extend your existing membership. I have two patents pending. One is a provisional and one is a utility. The utility is an energy conservation training mechanism, and that's being reviewed by a large company right now. And the other one is a significant improvement, I think, for LED lighting, for area lighting. And that's a field that I've worked in for years, so that's it.
And in the next phase of our introduction is milestones. These would be things that you might have achieved on the way toward, let's say, profitability maybe, or productization, is that a word? Are there any milestones?
Recent or just as a matter of story?
If you have any, I guess, relatively recent milestones? Yes, Ed.
My attorneys collected the last payment on our second of two lawsuits for a total of about eight people that didn't want to pay money, and I think being as the patent is now over a year old, expired over a year ago, I think that's going to be it. They told me money's coming, but they didn't sound too interested in doing another suit. So, that's it. Might have to do a real job.
So, yes.
Yes, I got one. I designed a world's lightest wheelchair for a company in Germany, and just won the Red Dot Award in Europe, which is a big deal for Europeans, not much in the US.
That's great.
Very good.
Lightest wheelchair, is that what you said?
Lightest, structurally, it doesn't fold up, but yeah. It's 14 pounds.
Wow.
Wheelchairs are very heavy.
Cool.
Any other milestones?
I'll give you one.
Sure.
I am Chris. I was working on a portable geodesic dome as a camping tent, and I found out the way my approach was not going to work. So that was a milestone because I don't have to worry about that anymore.
Yes.
I have a product that I put on market that one major company in this country took it and had it for 3.5 years. And sent me letters saying they loved it. Even got down to the point where they were ready to sit down and talk money with me. And the next thing I know, it was on the market.
Oops.
So that was my milestone.
They paid you for that though, right? Or did they
They
rip
never
you
paid
off?
me. They never paid me, and I never sent them a letter. I never complained about it. But I did complain to the patent attorney because I paid the patent attorney $15,000 for a patent.
Wow.
And I told him, he said he felt bad that they were within their legal rights the way they went around, circumvented my patent and made a product that one of their own, and that I didn't have a leg to stand on. But in the final analysis, with me signing papers and waivers and things, that I didn't make a fuss over the whole thing, why they come up with quite a sum of money for me. The patent attorneys, and I never pursued the company whatsoever.
I'd like to add a positive spin to this.
That'd be good.
I invented a utility. Didn't patent it, didn't sales, trademark it, or anything else. Sold the whole damn thing for $13.5 million.
Well, that's very positive.
Yeah, I thought you'd like it.
Yeah, if you're looking for a loan.
Was this through your employer, or?
I was the owner of the company.
Wow.
And I invented, basically took a bunch of software that somebody else had invented, put it together in a way they hadn't thought of putting it together before, and then sold the final construct to a public company that absolutely needed the utility and couldn't wait to redo what I'd already done. The funny part is when they approached me, they said, "Can we license that?" And I said, no, you can't license it. What I didn't say, it's not licensable because I don't actually own it. And they came back and said, well, we really want it. I said, can't license it, but you can buy the company. So they did. I said, okay.
Awesome.
So worked out well.
So you could afford to become a member.
That's probably true.
Yeah, but then he'd have to take you for a helicopter ride.
There you go.
Well, I think we've got more people coming. Wow.
Getting over the fence.
And remember I asked you if you know Gail Barrett? Rick,
Gail?
you know, you know Gail Barrett? That's her right there.
I tried to put up some
There you go.
signs. I don't know if you saw the signs.
Let's see her. Yeah, you had to leap the fence gate.
I did, I went around, I had to walk.
I was just telling Rick, you know, do you know Gail Barrett? She's an IP attorney in Westport. He goes, no. I said, well, there she is, right there.
Boy Scouts of America.
I felt that.
Yeah, there you go.
You make a grand entrance.
Just in the nick of time. There's a marker running around somewhere.
Well, you did fill the room. Absolutely.
Oh, and there's more handouts.
Yeah, let's pass some of these back.
Does everybody get a handout?
No.
Oh, we got one right in front of you. Oh, there you go. Anybody else need one?
Presenter.
What's that?
Nothing like a prepared presenter.
I keep bringing out markers and they keep disappearing.
I like this approach. He's got 3 plates that are going to go up on the
Here, have a,
one to take out.
Well, if you can still pass your medical, you can.
I would have to dump one of my medications.
Or you could drop down to the
So,
sport
I think what I should do is get the ball rolling here.
No medical
Doug,
required.
we have more
Signage sheets
Get
floating
something
around. We should get everybody.
Yeah, there are sign-in sheets and there are name tags. And what I'd like to do is introduce the speakers so that we can get the ball rolling.
Get a sequence.
Of course.
No, something I
Tell me
built.
how you pronounce your last name.
Michaud.
Michaud, okay. Richard Michaud, also known as Rick, is a founding member and managing partner of Michaud Kinney Group, an international IP law firm headquartered in Middletown, Connecticut. He has extensive experience in all aspects of IP law, including patents, trademarks, copyrights, and licenses. Take it away, Rick.
Thank you.
Rick.
All right. Thanks all for coming. As you said, my name's Rick Michaud. I'm a partner in a small firm in Middletown. We have 10 attorneys. We're just in the process of opening our small office in Tokyo, and we have an office in Beijing with 4 attorneys right now. So we've been floating around Asia quite a bit in the last few months. When Don and Tom asked me to do this, they said they had the IP 101 speech 100 times. So they asked me to do something on post-filing considerations and how to market your invention and what to look for. As I started putting this together, I realized that I could come up with 1,000 different scenarios on what could happen after you file your patent application. So I've tried to cover some of the basic things that can happen, and you guys should ask questions. Because if you ask a question specific to your particular situation, it probably has meaning to someone else, and it'll get us off onto other subjects. If you don't ask questions, we're going to be out of here early. This is kind of, focus that a little bit. There we go. This is kind of unrelated to what we're going to talk about tonight, but I thought it was important. There's been a Supreme Court decision that patent attorneys have been waiting for quite a while. It's called the Bilski decision, and what it has to do with is business method patents. Do any of you know what that means? All right, so business method patent is basically a patent directed to a method of doing business. Previously unpatentable, became patentable. Supreme Court ended up looking at it because a lot of people didn't want it to be patentable. So the case centered around the patentability of these business methods, and it's just simply a means for carrying out a business. And initially, it didn't have to be tied to anything. You could just have it means for carrying out a business. Then what happened was Bilski came along, and this lawsuit ensued. And the courts came up with a test. There were two parts to the test. First part to the test was whatever the method was had to produce a useful, concrete, and tangible result. That test was the stuff of more litigation and more rejections in the patent office because nobody could determine what a useful, concrete, and tangible result really was. The other part of the test was it had to be tied to a machine or had to transform matter from one state to another. So, in other words, you tie your method to a computer, or you talk about changing something into something else.
When you say software remains patentable, is that the source code are you talking about over here?
Source code, yes. Not necessarily the source code, the software itself. Usually when you get a software patent, it's almost like you look at a flow chart, and it's the steps that the software executes. Source code itself usually is subject to copyright. So anyway, what happened was in this case, and it's kind of an important case to us, because we thought that business methods might get wiped out completely. They didn't. They took away the one test and left the machine or transformation test in place.
Okay, so I'm going to assume that Supreme Court justices know the difference between software and algorithms, and that they know what they're talking about. And that's an awfully big leap of faith for me.
That's right.
But assuming they know this, okay, how can an algorithm not be patentable, but software be patentable, assuming you're not just going to copyright your code?
Yes,
I don't understand. How does that work?
Are you guys going to ask questions like this all night?
Only him.
He said the flow chart was patentable, but not the implementation.
If you think about it, it's the steps that the software executes.
And why is that not an algorithm?
That's right.
Arguably, it kind of is.
Okay, so this is just a debatable Bilski ruling. Okay.
But the software produces a result.
Right.
Okay, it's not the software itself, it's not even the flowchart itself. I think
It's the
that's
steps
not.
from A to
It's-
B.
And the result that's
Right.
produced.
So if I have an algorithm for finding prime numbers, that's not patentable, but if I write a program, it is patentable, but I don't have to write the
Does
program
something.
because I
It's
can
a
just write a
program and it
flowchart,
does-
which is really just the program.
It does something to something, causes something to happen.
It's almost like it has the European technical effect test.
Can any algorithm be cast as a flowchart?
I suppose it's
So then all algorithms are patentable as long as you can represent them as flowcharts.
That's right.
You can talk to the Supreme Court.
Yeah, I was checking, I'm sorry. Did I ask a stupid
I
question?
think,
It's just the stuff.
does that mean that
litigation's
because you mentioned about the machine, and the algorithm, if you put in that code, which you run on a computer as a machine, and so if that has been run on a machine, that becomes patentable.
As long as nobody else beats you to the punch, you did.
Can I comment on this? As far as the statement, algorithms are not patentable, I think it'd be more accurate to say mathematical algorithms. In other words, just the formulation of a mathematical equation and the employment of that mathematical equation, it's pure mathematics, is not patentable. But software, even if we call it, in fact, let's not call it a software algorithm, a software process such as writing software to control a machine to move a particular distance, that would be patentable, okay? Just by two examples. So I think we should qualify by saying mathematical algorithms and purely mental processes are not patentable.
And the other issue there is internet-related inventions. You know, there's a lot of those that are out there, where you have your situation where you've got the software tied to a machine. For example, methods of procuring goods over the internet. The Amazon one-click patent, which right now is in trouble. But things that are like that, you can't have it just be, as she said, it has to be tied to some result. You can't have it just be a computer that runs software.
Right.
It has to do something other than that. But internet-related inventions, and I think probably Bilski and its progeny are going to go towards questioning whether those are patentable or not, are where this is going to get the most action.
Do you happen to know what Bilski was doing?
I have one more thing to add to this. I have my own test, which I'd like to share with you. I call it the big head test. If there is a method that you can perform just in your head, that doesn't affect the outside world, that method would not be patentable. okay? So, I don't know, that test is not fully conclusive, okay?
Hand me that
But
microphone.
if you write a method claim, and that method claim could be executed inside your head or inside the head of a person, then that method is not patentable. Otherwise, a person such as Doug here, who's just thinking about the method and comes up with the answer in his head, would be infringing that method claim. So, I call it the big head test.
If I recall, this is not engineering related, but we had a big fight with this about the tax area, the guy for patenting the tax applications, and I think Bilski knocked that down, but it's the same concept. We were coming up with ideas, applying them to a software.
Yeah, where it had the
thing.
most effect was in the financial sector.
Yeah, the
was
tax
Bilski
code, they're trying.
prescriptions of commodities?
Yeah, commodities, right.
So Bilski, I think, negated that
Some of them,
protection, correct?
not all of them, some of them. It depends on the particular patent itself and what exactly the mechanism does. It's not every.
Well, they were patenting the tax code, actually.
Yeah, that, obviously.
But question, you used the word mathematical algorithm. Is there significance if you're choosing those two words? Some algorithms don't involve explicit equation or
Yeah,
number.
many algorithms don't involve any math at all. I use the phrase mathematical algorithm to illustrate my point that a mathematical algorithm is just really just something in the abstract. It's not necessarily something that affects the real world. It's a theoretical, actually it's something that occurs in nature. It's a natural, almost a natural phenomenon, which are other words that are used in the patent.
I'm sort of caught because a software program reduced to a flow chart to me is taking the software program and converting it into an algorithm.
Yeah, so avoid
That's a very
these,
gray
don't
word.
get hung up on the word algorithm then. If it's a mathematical equation, it can't be patented.
What you're talking about is an irreducible mathematical idea. You can't make it any simpler without destroying it. Patents, on the other hand, talk about things that are like molecules, things that are assembled from elements. You're talking about irreducible ideas, right?
Everything you're saying is true and correct, but I'm not only talking about irreducible ideas, okay? It's the language that's used in the Bilski opinion is abstract.
Yeah.
Okay, if it's something in the abstract, meaning it's just theoretical, it can't be patented. And certainly things that affect the real world can be patented. The question is, where is the dividing line between the two?
Sure.
Okay, but so back to my earlier example of having a program that can control a machine to move a certain distance. But if I have a program that does everything, does all of the calculation, but doesn't actually move the machine, it doesn't put an output signal, generate an output signal, would that be patentable? Okay, arguably it's not, because it's just an abstract result. It doesn't affect anything in the real world. But arguably it is patentable because although I haven't actually output the signal to move the machine, that's just a trivial post-inventive step. So one can argue that a software program that determines how far a machine should move.
Writing to those I/O ports is it's tough work. It's a lot of engineering. So I think that's why.
No, actually, I trust you being facetious. Writing to the I/O port is not hard work, okay?
The timing, the pulse widths, et cetera, that's all.
Yeah, but you usually don't include that in the patent claim.
So you want people to ask lots
Usually
of
don't.
questions, right?
You're on slide 1 of 75.
This is still a very tough issue, okay? Because
I-
much of the invention that's happening now in the real world, and particularly in countries like the United States, often does involve programs, computers and programs, okay? And defining that line between what's patentable or not is worth billions of dollars, at least millions, probably billions.
Yeah, especially the web-based stuff.
I would like to just add this one thing. I don't think it's possible for anyone here to demonstrate a computable mathematical formula that can't be cast as software.
Okay.
So I know this purely mathematical algorithm statement, I can't think of a single example where the algorithm for doing something mathematical that's computable couldn't be written in software.
Yeah, it could be, but that piece of software would not be patentable. The program to come up with that
But I
solution.
thought software is patentable.
Not all software.
No, that means,
Not all software.
what it really means is software is not on its face unpatentable.
Right.
I see.
Not every piece of software.
What's the second?
All right, we're leaving this subject.
Yeah.
Okay. All right. Again, we go back to what these guys asked me to talk about. What kind of things would happen and what kind of things could you do with your IP? And one of the things that I've been asked about is, how do you use provisional patents? What are provisional patents? And how best to employ them in a business? Provisional patent is basically just the detailed description portion of a regular patent application. In other words, a regular patent application, how many of you seen patents? You've all seen a patent? All right, so they have lots of bells and whistles. They have a background, they have a summary, they have a detailed description, they have drawings, they have claims. All a provisional patent application requires is a good description of the invention that's enabling. In other words, you have to be able to make the invention from reading what's in the description. And it's the best way you know of doing it at the time you file. So that's an easy way to protect your invention initially and allow you the time to go out and explore your market. What do I mean by that? What I mean by that is a provisional application has a lifespan of 1 year. At the end of that year, you're then required to convert it to what's called a non-provisional application, which is the one that you've all seen in issued patents. That 1 year period allows you to go out and see if there's actually a market for your invention. Now, during that time, you have to be careful to make sure you're not infringing someone else's patent, and I'll talk about that in a little while. But that 1 year period allows you that privilege, that right to go out there and explore it. At the end of the year, if you decide not to convert into a non-provisional application, your provisional application just dies. It goes away, it doesn't get published, it's just done. So it's a good economical way for you to get patent pending coverage and go out and be able to explore your market without worrying about destroying your patent rights.
So once it dies, then can that be revived?
Provisional application can't be revived.
So it has to be refiled in some other.
Yeah, and while I haven't, you should file prior to any public disclosure of your invention. What do I mean by that? If you go out and tell someone about your invention, you cause some problems, right? You start a 1 year clock ticking in the United States, which means you have 1 year to file, and you've basically destroyed your rights in every other country in the world, because the public disclosure destroys your rights in most other countries. So the problem with letting it die is odds are once you've filed your provisional, you've gone out and told people about it. So you can refile if you're within that 1 year statutory period, but you've probably damaged your rights in foreign countries.
Unless when there's disclosures under the non-disclosure agreements, correct?
Right. And if you use a non-disclosure agreement, that's certainly helpful.
Why did you destroy your rights? Because you basically disclosed it?
Well,
so from a
you don't
foreign perspective, it's disclosed without having been filed?
Right. Well, it's filed in the U.S., but it doesn't matter. Filing is not the issue with respect to foreign rights. Most foreign countries are strict novelty countries. A strict novelty country means if you disclose your invention publicly, you have before filing, you have no right to file. So what that does is basically destroys your rights outside of the U.S. In the U.S., you still have a year to file your patent application. But you're not going to be able to do anything in the foreign countries.
In today's world, that's very limiting.
It is, and then that's a problem for a lot of people because a lot of people don't know about these rules.
I didn't know about that one.
But, yeah, that's the rule. So you need to file your provisional before you go out and tell people about it. It's a good idea to do that. And as your invention progresses, usually during that year period, you're developing your invention. As your invention progresses, you cannot add to a provisional application. So you have to file follow-on applications if you wanted to. Now, you can tie all those together in a non-provisional application at the end of the year from your first filed application if you want to do that. But you're not going to be able to file additions to the provisional itself. You've got to file other applications.
What happens to that provisional patent? Did they actually destroy it?
It's not a provisional patent, it's an application.
The application that you sent?
Yes.
Is it destroyed at the end?
It's destroyed.
What's to keep you from making another provisional patent?
If you haven't, you can. You can make another provisional patent. You
Same
can,
thing, I mean.
You can, as long as you haven't disclosed it.
How long is it before they destroy the file that the provisional patent?
Well, the provisional patent only has a lifetime of 1 year from the filing date. So
Yeah,
at the
but
end of
if
that
you
year,
wanted
I
to-
don't know when they actually physically shred the file or destroy the file,
But they destroy them.
that's, yeah, they're not publicly available.
What's the legal definition of public disclosure?
The stuff we fight about a lot. But basically, if you disclose outside of yourself to anyone else, that can be considered a public disclosure. If you publish a paper, that's a public disclosure. Even if it's, it's been held one treatise on one isolated library shelf somewhere in some obscure university, can be considered a public disclosure.
If you talk to a friend. And
If you put them in possession of the invention, it's kind of like, you're not going to say, well, I'm thinking about making a flying car. That's not a public disclosure.
Oh, okay.
If you say, I'm thinking about making a flying car, and this is how I'm going to do it, that's a public disclosure.
What about if there's like a witness, like if you have a notebook where you're documenting your progress and everything else, and they witness your notebook, does that make it a public disclosure?
Well, if you're within your own company and you're all working on it together, that's really not a disclosure for all inventors. But if you have
Not inventors, you just...
If you go to your friend and say,
Right.
witness this and sign it, sure. That's a disclosure.
Public disclosure? Or is it just for evaluation?
It doesn't matter. It's a public disclosure.
So that starts at 1 year clock?
Start your clock ticking.
Okay, so you filed your provisional application and you do a confidential disclosure to a company that might be interested in your product, or maybe you do a bunch of them, and you go out and talk to several people. That's not considered public disclosure, correct?
You've already got your application filed, so you're
Right.
okay.
Right.
You're fine.
But would you answer his question specifically? If you have a non-disclosure agreement with somebody for a moment, even without filing a provisional, that's not a public disclosure?
No, not if you have an NDA.
In your estimation, which is better, a non-disclosure form or provisional patent?
Both.
Both.
Provisional patent is better because you don't run the risk of any, have someone sign a non-disclosure agreement. If they go out and violate that agreement, they've made a disclosure. So that can be problematic. Or if someone else sees it and goes tell somebody, so it could be problematic for you. So the provisional patent application protects you better. The non-disclosure agreement, why I say both, is because you can't enforce any patent rights in a provisional application. In fact, you can't enforce any patent rights until your patent issues. So the non-disclosure agreement, the breach of that is immediately actionable. So it's good to have both of them in place.
How does the foreign country know you've done any of this?
They don't.
But you said it voids your ability.
It does. And it does void your ability. I mean, you'd have to lie. I mean, they would never find out if you didn't tell anyone and you did it and you filed. Are they going to find out? Perhaps not. You may be able to get patents issued, but if they ever get litigated, it'll get found out, and then your patent's going to be invalidated.
But wouldn't they find out if it went from a disclosure or a non-provisional? I'm sorry, if you do a non-provisional first, and then when it goes to a provisional patent, it becomes...
The other way around.
I'm sorry, yeah, the other way around. But it becomes in the records then that you had the prior art, or it was...
Well, that's all right, though, because once you file your application, you're all right. You're not starting any clocks ticking by filing your provisional.
But I'm thinking for going for Europe, for a foreign patent.
No, that doesn't negate your ability to file in a foreign country. Your provisional patent application, the filing of that, kind of stops the clock ticking and stops the public disclosure rules from being applicable to you for whatever's disclosed in your provisional application. And then you have a year to convert it, and at the end of that year period, you also should make your foreign filing decisions, because then you get the filing date of the provisional.
I had a patent attorney that had a provisional patent on an item that I had after a year, I asked him to reissue that same thing, and he did it. Did he break the law?
What do you mean he reissued it?
He made another provisional patent.
Not necessarily. I mean, he didn't break the law as long as you didn't, you know, if there were no statutory bars, he can refile your provisional. If I say to you, did you tell anybody about it? And you say, no, I haven't told anybody about it. And you haven't told anybody about it for more than a year? No, I haven't told anybody about it for more than a year. You can refile the provisional. You know, there's nothing wrong with that. And if you haven't told anyone about it, you can refile it again and again and again, as long as you haven't told anyone about it.
Do you lose priority?
Yeah, you lose
Yeah,
priority.
you lose priority every time.
Not telling somebody means if there's a non-disclosure agreement, that doesn't count.
Right.
You brought up something interesting that I hadn't really thought about before. You said that the provisional application is destroyed probably once the utility patent issues. I would imagine
No.
it's...
No. If you convert it, your provisional application remains part of the record.
Ah.
If you don't convert it.
Oh, okay, yeah, because I was thinking, my understanding is that sometimes people will challenge a patent or challenge the original filing of the provisional, and if it's destroyed, then there's no record of that.
No, they don't destroy it. Then the other thing they'll challenge is the adequate disclosure in the provisional
Right.
to support what's in the
That's right, to support the claims.
Get that earlier filing date.
Right.
So the provisional stays as part of
the
file,
package.
file wrapper,
Yeah.
if you will.
Okay.
If you do convert it.
So conversion must occur before the year elapses, right?
Yes. If you want to maintain the filing date of the provisional application.
If you have a non-provisional utility patent, can you then go and get a design patent in Europe on the same? Obviously, you don't have to have the exact drawings.
If you have a non-provisional utility patent, can you get a design patent?
Yeah, I mean, like England has design patents that are, you can get.
You mean the design models that you can file in England? Yes, but again, the timeframes you have to be within the 1 year time frame, and then you can file a utility model. But I don't know why you'd want to do that.
Well, if you were late and didn't get your European patents, you're looking for a way to cover your butt right now. As I
Oh, you mean if I basically take the drawings that are in my non-provisional patent?
Yeah, I have a patent that I'm trying to sell in the U.S., a utility patent.
Yeah.
And I now have a European company interested in it, and it's too late to file in Europe. So I'm looking for an angle to get some protection. Yeah. I was thinking of a design patent, which I know I can get in England rather
Yeah, I tend
easily.
to doubt it because your utility patent's going to have all those drawings in it anyway, right?
Yeah, but it doesn't have to look exactly the same as it does in a utility patent. It's only the function.
Well, if it's different enough,
Yeah.
you may be able to do something like that, but it's a little risky.
Best I got going.
Something like that. You guys are good. All right.
Slide 3.
Come back next.
Well, I've gone through it. All right. So one of the things you talk about with patents is they don't have to be better than what's already out there. They just have to be different. So you got to know the needs of your particular market and your competition, depending on what you're going to patent. You know, there are many patents that aren't ever practiced. So that means there's a lot of money wasted. So before you go out and file for, you know, that's why provisionals are nice. Before you go out and file for a utility or a non-provisional application, make sure you know what it is that you need and what it is that you want to market, and make sure you protect your commercial embodiments. Because there are lots of patents that sit on shelves and never see the light of day. Because I've been talking about, here's a few of them. Call this the I'm not dead yet patent. This is an actual patent. What happens is this poor fellow here gets buried, and they're wondering whether he's dead or not. So they put this little clicker in his hand, and if he happens to revive, he closes that, and it starts a bell ringing and air flowing down into the casket, and hopefully they dig him up before the air runs out. So it's an actual issued patent. This is a patent for a bird diaper.
That's on the internet. You can order these things.
Yeah. How many of you ever had a bird?
Yeah,
You
they're
have it out of the cage. You're going to be lucky you have that. This is my favorite one. This is before elevators. So if you went to a hotel and you were infirm and couldn't really navigate the stairs that well, the bellman would take this little plow-like device, stick it in the small of your back, and kind of push you up the stairs.
How about going down?
They
roll you down.
This one is, you know, on the one hand, it's kind of funny. On the other hand, it's kind of scary. This is an anti-hijacking device. So this guy is sitting in the chair, and let's assume he misbehaves. You notice this little cylinder here? There's a needle in it.
Cool.
So it comes up through the bottom of the seat and injects him, and if you notice, it kind of knocks him out. It works well with screaming babies also. But, you know, these are actual patents. So, you know, did the guy explore his market? I tend to doubt it. Did he spend a lot of money on this? Probably. So, you know, it's the kind of thing that you really have to think long and hard about. I mean, these are silly, but my point is, if you're going to file for a patent, it's an expensive undertaking. You're going to pay me and John and probably Gail a lot of money to get you protection. And then at the end of the day, if it's not something that you can commercialize, not something that has any value outside of just saying, I've got a plaque on my wall, what have you done? So you've got to be careful and think long and hard about what it is you're patenting.
Steel diapers?
One of the other values in provisional patent applications, and we do this quite a bit with some of our commodity clients, you know, you come up with your invention. And it's the result of a request, let's say, from another company. They say, look, I've got a bearing design I need a solution for. Here's my problem. I don't know how to solve it. So the company goes and they engineer the solution. And then what happens is they give it to the requester, and the requester goes out and says, okay, thank you very much. I'm going to see who the lowest bidder is on this. So all the engineering work is gone, and you may not get the job. So file a provisional application. As long as you can make the argument that it's patentable, at least when you give it back, it says patent pending on it. And it's going to make it more difficult for them to shop the invention. Your provisional applications can be sold, and they can be licensed. It's a little more difficult to sell and license a provisional application because you don't know whether it's ever going to mature into anything. But it is possible. I've done it on a few occasions, mostly in the biotech field. We just did a large deal with Dana-Farber Cancer Institute, and we represented them in a biotech patent, and licensed the provisional to a large drug manufacturer.
How can it be licensed when it's not issued?
You can license it.
Wouldn't it be contingent on the patent being awarded?
Oh, my favorite legal answer, it depends. It depends on the terms you put in the license. You know, ultimately you have to license something that you own. If it ultimately goes abandoned or becomes public domain, you have nothing left to license. Now there may be know-how, there may be some trade secret in there, but ultimately it should issue as a patent. But you know, if the company sees the value in it and wants to make sure no one else gets it, they're going to go after it early. Never underestimate the value.
I was just going to say, somebody brought to my attention a while back that there's actually a tremendous advantage to licensing a provisional, because the company, if they have the legal the financial wherewithal, can, using your provisional, if it's a well-written one, can really spend a lot of effort in putting together a really tight utility patent. Maybe you wouldn't have the resources to do that, and they would have the opportunity to influence that utility patent so that it fits their business model.
Certainly that's an advantage. You know, you get someone else to pay for it. That's always nice.
Well, it's an advantage to me, but I'm talking to them, it's an advantage too.
When you get them to pay for it, they're not going to fork over without having taken the rights, most of the rights from you. You're going to have to give them some sort of an exclusive or some sort of a license.
When you switch from a provisional to a utility patent, you can change a utility patent quite extensively. I mean, other than what the provisional, or you have to use exactly the same thing that the provisional patent added.
No, you can change it, but what happens if you add material that's not in the provisional patent, you're not going to get the original filing date of the provisional for the new material you added. So you could end up with multiple filing dates. So when you file a provisional and then you convert it to a non-provisional, the non-provisional application will be afforded the filing date of the provisional application. So it'll be as though you filed that non-provisional a year sooner. And that's important to you. You want to have the earliest possible filing date you can get. if you, during the course of your development, that you come up with 17 other things you want to add to that provisional, well, you can certainly add them into the non-provisional application, the utility application as you're referring to. But when you do that, you're going to end up with more than one filing date, because you're not going to be afforded the filing date of the new subject matter if it wasn't supported by the provisional application.
Yeah, how does that work? Because you might have the first 5 claims that relate to your original provisional application, and then you've got a couple more claims that relate to new material.
You hope it's that clean, or maybe you don't hope it's that clean.
Yeah, but you know what I'm saying, though, is that, you know, you can't say that those first 5 claims have priority back to such and such a date, and these other claims...
Yeah, you can.
You can?
Yeah, sure. Yeah.
I've never seen that done. Really?
Yeah. Well, it's going to happen in litigation. They're not. The Patent Office doesn't say that.
Ah.
Patent Office doesn't say, well, these are entitled to this date and these are entitled to
They
that.
give you the original filing date, and then if somebody litigates it, then
you
it
have an issue
gets...
date for the patent, and you have a conversion date for the non-conversion.
Oh.
Yeah.
Okay.
Patent Office doesn't make that judgment call as to what's old and what's new. They actually used to way back when, but they don't anymore.
I've heard they hardly even look at the provisional.
They don't look at it. It's not examined. It's not. It's simply a placeholder. So it doesn't get reviewed. It doesn't get examined. It doesn't get commented upon. You know, if you're going to get in litigation,
that's another
it's
story.
going to get extensively reviewed, but not by the Patent Office.
Right.
So I tell you, go out and file your provisional. Do it early on. What's the importance of that? And you do it, and you go out and market your invention. Then you get a cease and desist letter because you're infringing on someone else's patent. So you should never underestimate the value of a search. Now, I have the word French fries here to remind me to tell you the story. A fellow came into my office, and I kid you not, his name was Odie Fry. And good old Odie had an invention that was for, you ever seen the boxes at McDonald's at French fries company?
Yeah.
Odie wanted to put a little drawer in that box that you could pull out and fill with ketchup. So you take your French fry out, you dip it in, and you eat it.
Right.
You know, great for my kids because, it's constantly this, and you've got ketchup everywhere. Comes to my office, I tell him, standard spiel, you should do a search, it's important, you don't know what's out there, and if someone beating you to the punch, there's 1 million issued patents or 7 million issued patents, and one of them might be yours, and he says to me, yeah, I know my business, I know there's nothing out there like that, I've searched the internet, I've done Google searches galore, and there's nothing there. Okay, fine, you insist. We file as non-provisional application, the Patent Office will do a search for you once you file. They go out and look to see what's out there. There's 1, there's 2, and there's 3. So Odie was done. Every possible permutation that he could come up with was already patented. Had he done this search, you would have found these because it's right on top of him. So he wasted a lot of money, a lot of emotional capital, and in the end, ended up with nothing. So it's important to consider doing a search. And a search isn't that expensive to do, depending on what you're going to do with it. Now, the other thing you have to be careful of is a lot of people go to the PTO website, PTO stands for Patent and Trademark Office, and do their own search. So they'll get on and they'll do a keyword search, all right? Now, the problem you have is as patent attorneys, we can call something anything we want, as long as we consistently call it that. So you're going to search a keyword, and I may have called it something different. I'll give you an example. We had an old wordsmith at my former firm who was a great guy to go to when he couldn't think of what to call something. So we were trying to patent aspects of a male-female connector. We're trying to think of a cute way to call it. So he comes up with the words, an hermaphroditic connector. It's beautiful, And you sit there going, oh, this is great, so you use that. But if you're going to go on to the Patent Office website and you're going to search and do a keyword search and say, I found nothing, you're not going to search hermaphroditic if you're thinking about plugs and connectors. His other great claim to fame was we had an underwear patent, and he called it a bifurcated nether garment. So you have to again.
Oh, God.
It's very difficult to do that kind of search. So you're better off, go on it, do it. We call them knockout searches. If you find your idea on there right away, you're done. If you don't find it, it doesn't mean it's not there.
Well, you can do a class search, too.
You can do a class search, but that's...
Would you have found that search?
Of course. There are no 100% guarantees that you're going to find it, but it's the best guarantee you're going to get. The problem with patents, and we've all seen it, I do a search, I say it's patentable. I file it, the patent office comes back with the first office action, and it's stuff that I never even saw, that the searcher didn't find, or it's stuff that I would have thought was irrelevant. Patent offices are examined by patent offices. Patent applications are examined by people. It's subjective. You know, they make calls that you wouldn't necessarily make. I used to represent, well, I still do, but a razor company. And I've had saber saw blades cited against me. I had a cheese grater cited against me. Now, I would never have looked in that art area for razor art. You know, and we ended up getting around those references, but the issue was you're going to see things that you may not have necessarily expected and that may not have turned up in the search that we might get back to you, but it's still the best vehicle you have to try and make sure that you're not filing something you shouldn't be filing. One of the other things you can do.
So to dumb that down, does that mean that you should do your own homework, but there's value to having professionals take a look at it because they'll find stuff you don't?
Absolutely. You know, and I assume in here we have a lot of individual inventors. And individual inventors, the one thing they don't always have is a lot of money. You know, that's why they're inventing, because they want to hit that jackpot. And do as much as you can up front. But don't make the mistake of thinking that the search you've conducted is exhaustive and that there's not going to be anything out there. Because if you do, you may end up like poor Odie there with nothing. By the way, I did call, I have a friend who's works for McDonald's, and I asked him why he hadn't done it. I said, oh, we've seen that 100 times. He said, it's a nickel container to do it. So imagine the number of containers they make times 5 cents. It's an incredible amount of money. So again, understand your industry too, because had he gotten the patent, he would have gone there and said, look at this great idea. They said, yes, it's a great idea. We don't want it. It's too expensive. So you've got to kind of make sure that what you're filing has some validity and has some value out there in industry. That's why the provisional is nice. You can go out and explore your market for relatively little money.
What's the value of giving the list of references in the provisional disclosure?
Giving a list of references? None.
Okay.
There's no value in listing
so that's only
prior art, if you
personal
will,
record
in
or
the
company record, really.
But you raise an interesting point. When I file the application, the patent office rules say I have an obligation to tell the patent office about anything I'm aware of that may be material to my application. So if you have that list of references and you know about it, save it, because when we convert it to non-provisional, we're going to have to file an information disclosure statement with the patent office saying, here's what I know of already that's out there that's related to what I'm inventing. And then withholding that becomes fraud on the patent office.
Okay.
What would be general price
So it's
range
not
on
really
professional
voluntary.
search?
Excuse me.
So I'm confirming that it is not voluntary.
What is not voluntary?
Including the list of references that one.
You can do it. I don't see any value in it for a provisional application. I mean, it's good for you to know that that's out there, but I don't see any value in putting it in there. I'm
Okay.
sorry, no, go ahead.
What would be general price range on professional search?
And a professional search. Again, it depends. And what it depends on, average for the searcher, $500-600. You know, and what happens then is, does he come back with 1 reference or 25 references? So the fee for the patent attorney to give, bless you, his opinion is going to vary from, you know, a few $100s to a few $1,000s. It depends on how many references comes back. So what we typically do is we'll say to you, you know, look, we'll do the search, and when we get the search back, we'll give you an idea of what we think it'll cost for an opinion. I've had a lot of inventors, individual inventors, say, no, I just want the search results. I'm going to sort through it and figure it out for myself. Certainly I can't make you not do that, but it's kind of a bad idea because patents are written in patentees, and so lay people have trouble understanding what exactly they say. So you may miss something that is important.
Does the opinion typically include both patentability and non-infringement, or are those two separate?
Two separate. Yeah, non-infringement, you have to have something that you think, you know, you'd have to say, here's this device out there, do I infringe it? You know, or here's this patent out there, rather, do I infringe on any claim of the patent? So that would be, it would be premature to say a patentability opinion and a non-infringement opinion. You have a question? One of the other things you can do, we get a lot of companies that I call, commodity companies that have been around for a long time, that may have, blanketed their technology area with what they call seminal patents. So then what do they have to do? They file a lot of smaller patents to cover a particular niche area that they want to stay in. For example, I've represented Schick, and their biggest competitor is obviously Gillette. And both of them have tech areas that they have surrounded with patents. One might be handles, one might be blade technology, one might be coating technology. And so there's a lot of horse trading that goes on between these two companies because one won't go into the area of the other for fear of getting tangled up in a patent infringement suit. So it's an expensive way to do things, but if you do get to that point, you may want to think about making sure you cover all your bases in your tech area. And when you finally draft a patent application, what you want to also be sure you do is not only include the embodiments, the individual designs, if you will, that you want to have protection for. You want to also include those embodiments and designs that you don't want anybody else having protection for. So you may have figured out a less desirable way to do it. You want to make sure you include those in there so that people can't do, because if I heard you right before, it sounds like what happened with your application is somebody changed your invention enough to get around the patent.
You know what happened to my application was the lawyer was smart, he sent me the application, told me to review it, and I said to myself, well, this guy knows what he's doing, just file it. I should have read it, and if I'd have looked at it and helped him and done my homework, I think I'd probably made out all right.
And you never read the application?
I never.
That's an interesting point, because what you're going to do when you file an application is one of the things you're going to sign is a declaration saying you're the inventor of everything in that application. Read your application, because if it turns out that you never read it, that's problematic for you later on down the road.
You're saying it's important to document lesser solutions that aren't as good as the one you're happiest with, as long as the one you're happiest with is also in there.
You're required when you file your application to include the best mode, the best way you know of filing your invention.
But the lesser modes are valuable to you because they offer you some kind of umbrella against competition?
Well, they give the competition less room to go around you. The patents are not only offensive, they're defensive.
Best doesn't always win, right?
And cheapest sometimes win, and the best marketing sometimes wins.
Right, beta versus...
more likely the best marketing wins.
Right.
How many blades are you going to put in the razor? 10? It's all marketing,
Wouldn't another reason be that when you try to commercialize something, you're not quite sure at this stage, at the patent stage, what the company might find valuable, or to put it into production, they may think that some other aspect of it is more valuable, even though you didn't think so when you were just inventing this and filing for it.
Yeah, so. Very true. Brainstorming sessions. I hate brainstorming sessions. The reason I hate them is this. How many of you have ever been in a room with a bunch of other engineers trying to develop an invention? All right. By the way, I was a mechanical engineer. I have 2 degrees in it. I was an engineer for 11 years. I sat in a lot of these. At the end of the brainstorming session, each and every one of you think you invented everything. And that can be a problem, especially if you have people from other companies sitting there. And why is this dangerous? Who's an inventor? What's the definition? Anybody know what an inventor is? Like, you two can't answer.
Somebody needs their head examined.
All right. Inventor. Easy definition. Anyone that materially contributes to at least one claim in a patent. So, if you're an inventor, if you materially contribute to a claim, you have to be listed as an inventor on the patent. If you didn't, you shouldn't be either. If you look at the patent in my name, one of the first names on the patent is the Senior Vice President of Engineering, who never saw it until 2 days after it was filed. So, questionable. Is it valid or not? Probably not. Inventorship has to be right. The other problem you have, though, if it's wrong, one or more of your claims can be invalid.
Didn't Edison put his name on all of his patents? And did he really do all the inventing on
Next
all
time I
the-
see him, I'll ask him. You know what the answer to that is? The rumor mill is no. He didn't. I meant to tell someone about, I think it was you that said you knew, you found out something that didn't work in one of your inventions. When they asked Edison how he invented the light bulb, his statement was, "I ran out of things that wouldn't work."
Well, when he was working on the light bulb, he invented the one-way valve, the diode, which is a far more important invention to digital computers than being able to see in a room.
When I run brainstorming sessions, I always put the initials of the person up to the comment when you get all the comments. I've always said that protected, because I didn't keep a list of everyone who was in the meeting.
We'll talk about a better way to protect that in a minute.
Okay.
That's arguably okay, but then the guy that did it will say you're a liar. You know, if there's no corroboration.
We usually have at least 9 corroborators.
So here's the other loaded question. You know, if 4 people are listed as inventors on a patent, what's the ownership interest of each inventor?
100% each.
Of course not. It's too easy, but.
What is it?
Depends who it's assigned to.
Well, that's one answer. It depends on who it's assigned to, and if all 4 assign it to the same entity, that entity is the de facto owner. But otherwise, if 4 people are listed on a patent as inventors, each inventor owns 100% undivided interest in the patent and can go out and do with it what they want. So that can be very dangerous for you.
Can each of the 4 attempt to sell it exclusively to someone else?
You bet.
Really?
The thing that I had 2 things happen to me. I inherited an infringement suit, and what happened there was one of the inventors didn't assign his invention and kept his rights. He went and licensed the infringer. Kind of ends the infringement suit. I also had a case where an inventor died and didn't assign his rights, and his wife ended up with his rights. And the problem with that became the lawyer that represented his wife held the company hostage because they were going through financing, and she ended up with a large equity stake in the company, much larger than her husband would have gotten, because they had to do that in order to get the deal done. So it's important, 2 things. If you're inventing with friends and relatives, get it in writing as to who owns what and how it's going to be handled. And if you're owner of a company, have your company employees sign employment agreements that make them obligated to assign their invention rights to the company. Otherwise, you can run into these nasty, ugly little situations that are very difficult to extricate yourself from. So what makes a brainstorming session dangerous? Now, I just told you, everybody's going to think they're an inventor. Every inventor owns 100% undivided interest in the patent. You're going to have these terrible fights between who the patent should go to, who it belongs to. What do you do to prevent that? Before you go into the brainstorming session, file a provisional on every idea you have. So that way, at least if they come and say, wait a minute, I had this idea first, you can say, no, you didn't, and here's my patent application that says I did. That way you negate the effects of everybody saying I invented it. The other thing I want to talk to you a little bit about, someone raised the question about design patents, and you shouldn't underestimate the value of properly drafted design patents. I know a lot of people think they're useless, and some of them are, depending on how they're written and how they're drafted. It's more how the figures are made. But there are cases where if you want to protect the aesthetics, a design patent goes to the aesthetics of your invention, what it looks like, not the functional aspects of it. There are situations where it can be very valuable to protect it. Everybody recognize that? It's the Statue of Liberty, right? So the French were kind enough to give us the statue in pieces. We didn't have enough money to put it together. So you guys know who Pulitzer is, the prize was named after? Went around and literally collected pennies from school children to erect the statue. The other thing they did is they sold miniatures of the Statue of Liberty. How did they prevent everybody from knocking off the miniatures and selling them as a profit? They filed a design patent for the Statue of Liberty.
Wait, doesn't that have to be done by the sculptor or the designer?
Abe Bertoldi.
Oh.
Yes, it does, but he agreed to. This is one that a long time ago I worked on, and it's to a butterfly-shaped sprinkler. So the patent is to the shape of the sprinkler. The guy that got the patent, it was just him and his mother working in a small place in Norwalk making these sprinklers. They went to a design show, and about 3 weeks later, his wife comes running and said, "I didn't know you sold your sprinklers to this big box retailer." And I didn't. That was the picture on the big box retailer of the sprinkler. That was the picture on his box. They had seen it at the design show, had it copied in China, and went out and sold it to one of these big box retailers. Moral of the story is I would never, ever recommend patent litigation as a revenue generating prospect. But in this case, we sued the company that sold it. I mean, it was, you don't get much more slam dunk. They made more money on the settlement than they ever made in all the years they sold these sprinklers. Now, we're not talking about a lot of money because you don't make a lot of money on sprinklers. But had he not had the forethought to protect his design, he wouldn't have had a leg to stand on. So there is a lot of value to those types of patents if properly done.
So this only had a design patent, not a conventional patent?
You had it hard to get a utility patent on a sprinkler.
Yeah.
You know, so it didn't really lend itself to utility. I mean, all it did was spin around when the water pressure came up there. And, but it did lend itself very nicely to a design patent.
The dustbuster for most of its life was protected by a design patent.
That's true. The other one, Nike and Reebok, when they come out with new shoes, they're, you know, you see them, the lady, my kids buy them. I got a 17-year-old. They look like space boots. I don't understand why he wears them. They're the ugliest things. But anyway, what they do is they will file multiple design patents on that shoe. Now, in a design patent, you can file it on small aspects of the design. In other words, you show the whole shoe in dotted lines, so that's not considered part of the design that you're trying to patent. And then you show just the toe portion and the pattern on that as one. And then you know, put the toe portion in dotted line and show another aspect of it in solid lines, and you're patenting that aspect. So they would file 10, 12, 15. Reebok was very known for it when they first came out with that pump shoe. And then Nike Air tried to copy it. So, you know, they do have a lot of value, but you've got to be careful how you draft them. If you just put a picture of what you have and throw it in there, it's difficult to defend it. You've got to be careful what you do when you draft them.
How about the financial price of a design patent against a provisional and the others? Is it in?
Provisional, design patents are probably the cheaper of the three. The provisional, it depends. And why it depends is, you know, a lot of times if I have a very savvy inventor, he can give me a very, very good write-up on his provisional application that I can almost use as the provisional. In fact, there have been many times when I've gotten the call, I'm disclosing this tomorrow, what do I do? You know, I've got this paper I'm filing tomorrow, or publishing tomorrow, give it to me and we file it as a design patent, provisional patent application. So provisional patent applications can go, you know, they can be $500, they can be $3,000, you know, and they can go in between. Utility patents are significantly more expensive. A design patent depends on how many drawings you have. That's the biggest cost, is usually the patent draftsman. But typically in our firm, $500 to $800 usually for a design patent application.
How long are they good for?
14 years.
And the less detailed, the better.
That's absolutely true.
Is that price for the life of the patent or just the initial filing?
Well, once the patent issues, there's really no other fees associated with it other than the maintenance fees.
The maintenance.
Yeah, they're not.
They're cheaper too?
No, they're not.
No, I don't know the answer to that question. I don't know.
Are there PCT design patents?
Not really. Never filed a PCT design patent.
Why the less detail is better on a design patent?
Well, the more detail you have, if I have the more detail I have, the easier it is for someone else to get around it by leaving some of that detail out. For example, we had a patent to a uniquely shaped air freshener. the design patent that was involved in the lawsuit showed every vent. We didn't have the patent, the other side did. Showed every ventilation hole in it. So, but the same exterior shape. Our guy basically copied the exterior shape. We got sued for patent infringement, but we didn't have the same air vent patterns that they had. Had he left those in dotted line or left those out of the drawing, he would have had us.
With the evolution of the technology, you can do, for example, we have in Fairfield School of Engineering, we have a software which once you do the design pattern, you can do simulation in 3D. After this, you can put with rapid prototyping. And tomorrow, my nephew will go to Connecticut Center of Advanced Technology.
CCAT.
Then CCAT, another technology, 3D scanning. This means to do now one invention, with a new method, you can do physical and show everything working. I mean, everybody can do many inventions with the new technology more than before.
With the rapid prototyping, sure.
Exactly.
When you have the solid model, you can also do all the finite element analysis also.
Yeah, exactly.
If I can add one thing, if you do your design patent on a computer, you can get screwed because you can't tell the difference between whether that's a line or a through hole. So I can give you an example of one that got thrown out, not mine.
In other words, it was confusing to the examiner.
Yeah, it didn't have the correct lines to the way it's supposed to be illustrated.
Yeah, and then when you try and file that design patent in Europe as a design patent, they don't like the dotted lines, so you got to take them out. So it becomes a little difficult. Yes. Anybody need a break? Non-disclosure agreements. Use them if you can. And I'll explain what I mean about that in a second. They can toll the bars to patentability. Still better to file a patent application before disclosure. Use them even if you have filed for patent. You know, patents are held in secrecy until they publish. They publish 18 months after they're filed typically, unless you pay money and opt out of it. You can't enforce your patent rights until the patent issues. You can sue immediately for breach of an NDA. And I put bilateral versus unilateral NDAs in there for a reason. Unilateral NDAs means one-sided, specific to you. Bilateral NDAs means you agree to protect their secrets, they agree to protect yours. A lot of times you won't be able to get whoever you're asking to sign an NDA to sign it if it's unilateral. So sometimes it may behoove you to go in front of them and say, look, let's be fair to each other, you know, from a practical standpoint. This non-disclosure agreement includes both provisions for you to not disclose my secrets, and I also will not disclose yours. So those can be fairly effective when you've got a resistant person on the other side.
I got a question. Whenever you sign a non-disclosure agreement, you have it with the, let's say for example, if I retain you to represent me, how long will it last between you and I? Let's say you did the research and everything, and now I don't have enough capital to continue. Now, at what point are you obligated not to tell?
And the answer to that is, it depends, and usually that's written right into the agreement. However long you have to hold it in secrecy. Now, there are exceptions. You know, typically those are in non-disclosure agreements also. For example, if suddenly the invention becomes publicly known, you can't be expected to hold it in secrecy. If you learned about it through means other than from the person who disclosed it to you, you can't be expected to hold it in secrecy. If you, in fact, were working on it yourself when it was told to you, you can't be expected to hold it in secrecy. So in other words, if you find out about it through legitimate, non-illegal means, typically the NDA will say in it, you're not going to be held to secrecy. That negates the confidentiality. Usually these things have 3 to 5 year lifespans. I've seen some with a lot more than that. So one of my points is, you know, read the non-disclosure agreement very carefully. The other thing you got to read very carefully for is engineers pull them out of their drawers. They've been sitting there for 6 years and they don't read them and say, sign this. And when you read it, it's specific to a particular project. It doesn't make sense to you, and it becomes a problem. So it makes sense to you to be careful, read them. Don't just say, oh, it's a boilerplate NDA, sign it. Read it.
With respect to how long they last, when I write them, I always say that, you know, the term of this agreement is as long as we're negotiating over whether we're going to do business together, but the non-disclosure provisions continue beyond that. And I explicitly say there's no intention to transfer control of intellectual property in this agreement. And I think that will be respected.
If you sign a non-disclosure agreement with a company and the company goes out of business, what happens? Because
if they disappear completely, I don't know how they'd ever enforce their non-disclosure agreement against you. Arguably, they might be able to. Usually they slide over to any successors. If the company just disappears, I'm not sure what would happen then.
So you, excuse me, so you filed a provisional patent, and then you want to talk to somebody and they refuse to sign an NDA or confidential disclosure, whatever you want to call it. Where do you go from there?
How important is this person that you want to talk to? And
how much risk am I willing to take? Is that?
Well, again, you have your patent application on file. Let's assume
right.
your patent ultimately issues. So you'll have enforceable rights to protect whatever you've claimed in your patent.
Right.
So that may be enough for you. If, let's say, your invention, and you're going up in front of J&J, they're the biggest player, Johnson & Johnson, they're the biggest player in your particular field, and you present them with a non-disclosure agreement, and they say, I'm not signing this. You may want to tell them anyway, you've got a patent on file, you've got to rely on those rights then. Venture capitalists typically won't sign non-disclosure agreements because they're talking to 10 other people in your field. So they're not going to bind themselves. So then your rights will be those in patent. Go you one further, the big company will probably present you with an agreement that says, not only are we not going to hold it in secret, we may tell the world about it, we may in fact be working on it, and the only rights you have are your rights in patent if you ultimately get one. And I tell my folks, you know, all right, so you're going to hold fast and not sign it, and you'll own 100% of nothing. Right. That's just great. Yep. You know, it's your invention, you've got a plaque on the wall, and you've paid me a lot of money. I'm always happy about that, but you're not going to be. So the issue is, you know, you may have to sign it just to get in front of them.
So at that point, you probably would be better to go in with the legal representative? No? Doesn't make any difference?
Maybe, but typically you show up with their lawyer, your lawyer, they show up with their lawyer, and then it becomes an argument between the lawyers.
And that's worse.
My advice is have your patent applications filed before you go there. Ask them to sign an NDA. Odds are they're going to say no. You got to decide how valuable they are to you, and then if they present you with an agreement, read it very carefully. But, you know, I've advised a lot of my clients, sign it. This is the only way you're going to get them to look at your idea.
Try and document the fact that the meeting took effect, or actually occurred, rather? Does that?
Again, maybe, but if you're not going to have a non-disclosure agreement, if they're not going to sign one, they're not bound by anything.
Right.
So they can go out and tell the world about your invention anyways. You know, there might be some unfair competition issues in there, but odds are that, you know, they're going to be free to tell everyone about it. So the issue is have your patent application filed. That's the value of a provisional. It's not that expensive, and you can go in front of them and confront them.
I work for a large company, and the issue is people come in with ideas. Mostly they aren't worth anything. And
sure.
He doesn't want to get caught up in the possibility of what will appear to be nuisance litigation later on when something comes out, or we might not want to disclose to you what we're working on. So it's generally you have to sign it and trust them. If it's worth anything, they don't want it out in the public domain either.
Right.
Yeah, many companies will refuse to accept unsolicited ideas. They just don't want them.
That's something I've run into recently too. I was really kind of surprised. They didn't even want to know what the subject material was. They just said, we do not get involved in other people's intellectual property.
They don't want to get
Then I was stunned. I don't know.
You know, there's two ways to look at it.
That's contrary to my experience. I have seen instances where the prior to any kind of conversation was a statement that any kind of idea that you divulge will become our property.
I probably wouldn't talk to them.
Right. And I worked in the past for one of those. That was DuPont Company.
Well, if that's in your employment agreement, and you're working for them,
These were the visitors from other companies who
I
were
say,
the line.
read these agreements very carefully. I've seen them, you know, agreements where you license or you sell your invention to the company, and then they turn around and say anything that you develop that's related to this agreement, to this invention, or that's, you know, an improvement to it, we own that too.
Yeah, that's
So,
right.
you know, again, you gotta read it very carefully. And if you're willing to accept that, fine, you know, it depends on how much money they throw at you or how desperate you are. But
And
at
a
the
lot of
end,
it was also going on in the job interviews.
yeah. Oh, yeah. Well, I've seen it happen a lot of times. I've seen it happen where people didn't know they were doing that they were assigning their rights to the company. They just signed their employment agreement, didn't read it, and then they come later on, they leave the company, and usually there's a, you know, term after you leave that's still affecting you.
Yeah.
They invent something, and then they're shocked when the company comes after them. They come to me and say, what do I do? And I read their employment agreement. I said, you give them the invention, you know, or you have to choose to fight if you can. But it's difficult, so you've got to be careful what you sign, and you've got to know what the terms and conditions are.
How about going back for a second shot? Guy that got stuck by a big corporation, and then figuring that there had to be some honest people in the world, and calling that same corporation back.
One of my slides here says persevere.
And they sent a representative to my house. He spent 2 hours at my house. They flew me to Chicago, put me up in a big hotel, gave me a tour of their factory, and after I divulged everything I had to show them, they said they didn't want anything.
Thank you very much, yeah. Yeah,
So
well,
there's a sapo.
I suppose that can happen.
Yeah.
Again, you know, you're in the less leveraged position, depending on how much they really want your idea. But, you know, taking a step back and let's assume that the negative aspect of that didn't happen, and the first guy says, no, we have a policy against that, it doesn't mean you can't call somebody else and ask them. Most individual inventors, you know, they come into my office, I would say 1 in 50, if I'm lucky, actually is successful in commercializing their invention or selling their patent. And there's a lot of reasons for that, but one of the reasons is they either think that the world will beat a path to their door because they've had a better mousetrap, and that's not true. You know, there's a lot of, no matter how good your idea is, you got to pound on a lot of doors. A lot of people go to these invention submission corporations. You know, my opinion is just run away. You know, they do very little for you. They take a whole lot of money for you. In fact, they finance your patent as though it was an automobile. You know, I've seen these incredible agreements where people have spent tens of thousands of dollars on absolutely nothing. I had one come to me last week, and she said to me, my brother's patent, my brother is now in a nursing home with Alzheimer's. They've just asked him to sign the improvements that were made to the patent. I said, well, did he invent it? No, he didn't invent it, but this submission corporation wanted him to sign off as though he had. Now, he couldn't even write his name, didn't even know his name anymore. So, you know, these companies are very dangerous. They'll present you with a book showing these incredible market studies, showing you how valuable your patent is. I've probably seen a dozen or more of these. They all say exactly the same thing. They just change the name of the invention on the book. So, you know, really be very selective as to who you let market your invention for you. It's not so easy to market it. The ones that have been successful that I've had do it themselves. And just, you know, put a lot of shoe leather down on the ground. All right, let's talk a little bit about foreign filing. So you file your provisional. You got 12 months to go to a non-provisional. You should also consider converting, or rather filing your foreign applications at the end of that 12-month period so that you can get the filing date of the provisional for your foreigns. Now, why should you do this? Well, foreign filings can be very valuable to someone who's interested in your invention. If they get more area they can protect it in, it may mean more money. If they want to make it in China, or they want to make it in Japan, they want to be able to try and protect it in those countries. So it makes sense to have foreign filings where you can. The problem with foreign filings, especially in Asian countries, is they're incredibly expensive. One of the biggest expenses is the translation fees. Everything has to be translated from English to Chinese or English to Japanese. So it can get very expensive for you when you're filing. So one of the ways to protect yourself for comparatively little money is to file under the PCT. PCT stands for Patent Cooperation Treaty. And basically, and this map is probably a little outdated, there may be more countries now, the dark blue are the PCT countries. Basically what it allows you to do is file one application and be able to designate every one of these countries for a fee. And at the end of a certain period of time, and it's usually around 31, 32 months, you are able to designate exactly which countries you want to
Good
go in.
evening.
At
The
that
time
point,
is now 8:30 and the library will close in 30 minutes. Please bring all items you wish to check out to the circulation desk at this time and collect your personal belongings. Thank you.
talk fast. So anyway, you can file in these countries, then at the end of that period you're able to enter into the foreign countries, and that's when you have to pay the fee. But filing the PCT application, if you're going to market your invention, can give you a lot more leverage with companies that might be interested in buying it, because it gives them the ability to protect it elsewhere than just the US. People ask me about China. We have a small office in China. Remember, your patent life is 20 years. You know, enforcing it, China 5 years ago is a completely different country than China today. Enforcement there is getting much better because they're filing a lot of applications here. I forget what the statistic was. I think it was in the last 2, maybe 3 years, they filed 700,000 applications in the US. So, the reciprocal rights that we're granting them and the fact that we're allowing them to do that, we're putting more pressure on them to be better about protecting intellectual property in their countries. So, you know, I tell people 5 years ago I would have told you no, but today you might want to consider China. So, you know, you've got to think long and hard about the countries you want to file in and make sure that they make sense for your particular situation. Scope of U.S. versus foreign patents. In the United States, when a patent gets examined, it's really a literal examination. They go element by element in a claim and compare it to whatever prior art, other patent documents that are out there, other publications that are out there, to see if that reads on your invention. So it's a very literal type of examination. So you may get a certain scope based on that limited type of examination. In foreign countries, it's more gist of the invention examination. So they're going to look at your invention and do the kind of engineer versus scientist. You know, the old joke, you put a bar of gold at the end of the room and you tell and a scientist and an engineer at the other room, and you tell a scientist for each step you take, your next step has to be half as long. Whoever gets there first gets the bar of gold. So the scientist doesn't even try, says it's impossible because I'll never reach it. The engineer takes 3 steps, goes, close enough, grabs it. That's kind of the gist of the invention argument for the foreigners. You know, it's a less literal examination. They look more for what they call technical effect. What is the effect of your invention than the element by element examination that we do in the United States. The other thing you have to remember in this country is patent rights are exclusionary, not inclusionary. Just because you have a patent doesn't mean you can go out and make the invention. What do I mean by that? Simple example. Tom has a patent for a table with 3 legs. Don thinks he's going to be clever and he's going to go out and make a patent, make a table with 4 legs. Would he infringe that patent?
Might.
Yeah, sure. Tom owns the underlying rights to that patent. Let's say Tom makes a 3-legged table patent, and you decide you're going to put some improvement on it. You're going to put one of these electrical boxes on the top of it. So you want to go out and market your table with the electrical box on it. Tom sues you for infringement. You infringe because you still have a table with 3 legs. Tom likes your electrical box patent. He wants to use it, so he would have to license you because he can't put it on it because then he would infringe you. So you get the right to exclude others from making, using, or selling. You don't necessarily get the right to make your patented invention.
If If you have a patent on a technology in the United States, and someone, a Chinese manufacturer incorporates it into a product, can they then sell it in the United States, even though if it's made overseas?
Yeah.
And they're a Chinese
You
company.
can't sue them for the making of it overseas. But remember, you get the right to exclude others from making, using, or selling. So they can't bring it into the country. And there are actions besides the federal court you can take before the International Trade Commission, which is beyond the scope of this talk. But yeah, they can't bring it in. You can't go sue them. And let's say you had a patent in the U.S. They can sell it everywhere else, and you can't stop them.
Yeah.
Your patent rights in the U.S. are only good for the U.S.
If in foreign country you have one product, which in the United States you don't have, and you patent there, after this, for a while, you find out the United States can apply. What happened?
The United States can't apply for a patent if it's patented somewhere else.
But the product was introduced.
If the product comes into the U.S. and there's a foreign patent on it?
Yeah. Because I saw, especially in automation, American companies, they copy from a foreign company.
Well, sure. I mean, I think that happens a lot and vice versa. The issue is if they've only got a patent in France and the U.S. wants to make the same thing here that's in that patent, and there's no U.S. patent and they're not going to market it in France, there's nothing that stops them from doing it because they have no right to, enforce that patent outside of their country, the country that it's issued in.
But if you have a patent here, you patent, okay, and you want to patent it in Europe, and somebody in Europe did something similar to your patent, then how does it work?
Well, my favorite answer again, it depends. And it depends on when did they do something similar. If they did it more than a year before you filed for your patent in the United States, you're really not entitled to a patent in the United States.
Even if they didn't patent in the United States?
That's right. That's right. So the issue becomes, when did they do that, and how long before your filing did that take place?
So when you search for a patent, you have to search also in other countries?
You don't have to. You can, and the issue there is it's a matter of money. One of the things that typically most major companies, if they file in Europe, they're filing in the U.S. too. So you're going to find, provided that 18-month publication period has passed, you're going to find the same patent here, or the same patent application here. If you really want to be thorough, yeah, you should do a foreign search, but then you're talking thousands of dollars to get that search done.
I don't know if this is the right time to ask, but how do you force your invention to become public domain? In other words, prevent anyone from patenting it?
No, it's not the right time to ask. Disclose it. I mean, there are ways you can file in the patent office, but disclose the invention. Once your invention is disclosed, no one else is going to be able to get a patent on it.
What's the definition of
In
disclosure?
the U.S. or everywhere?
Published?
Published, yeah. In the U.S. or everywhere?
Yeah.
If you disclose your invention in the U.S., you're pretty much barred from getting a patent anywhere else in the world.
And everybody else?
Everybody else. Okay. So what do you want to do with your patent application? You want to sell it? One of the things that you got to think about is be realistic with your expectations. I've seen many inventors come through my office, and you need to recognize the fact that whoever buys your patent or application is going to have to likely make large upfront investments if it's something that requires tooling or manufacturing. So they're not going to pay you gajillions of dollars, and then they have to also expend gajillions of dollars to come up with your invention. The other thing you have to make sure of, remember I talked about, make sure everybody's assigned their rights so that if you do go out to sell it, there's nobody hanging out there with rights that they can't get. Most likely, if there's someone who hasn't assigned or is not agreeing to sell their interest, no one's going to buy it anyway. So your employment agreements are very important. The other thing you have to be careful of is if you do generate interest, and when I say be realistic, I've had lots of cases where people have had an invention, They've gotten realistic offers, but they're sitting there saying, you know, this invention should be worth millions of dollars. And they've got an offer for, say, $500,000. And they refuse to take it. Well, 5 years later, still nobody else buying it. So again, you own 100% of nothing. So you've got to be realistic about it, and be careful attaching conditions. The thing that always happens to me is I'll get a good offer, and then the owner says, well, they have to buy 500 hours of my consulting time. They have to fly me first class over to Europe because that's where they're going to make it so that I can make sure it's made to my specifications, and they blow the deal. So you've got to be careful with what you do when you're getting someone interested in your patent. Don't put too many conditions on, and be realistic. You know, the dollar signs in the eyes. These days, you know, there are very few inventions that someone's going to come and say, I'll give you $10 million for it. You know, so you've got to keep in mind that it's realistic. Except you, who sold a non-patented invention for $13 million.
Well, I was going to just comment on that. The public companies saw what we had accomplished. They saw the end result. So they wanted to talk about licensing it, which wasn't an option. So they all flew out, the whole team of tech weenies. And they're running around my server room with little pads, and they're doing this. They're writing down the logos that they see on the screens. And of course, I see them doing this. So I say to the chairman, bring your guys over here. He goes, fellas, I'm going to give you the logos. You can stop writing it down. Oh, we weren't doing that. I said, yeah, you were. But I'm going to give you the names of all the software involved. And the head tech guy goes, why the hell would you do that? And my answer was, look at it this way. The chairman here has one daughter. She's getting married in an hour. 2,000 people are coming to the wedding. I can give you the ingredients to the cake, which will take 3 weeks to bake. Or you can drive out of here with the cake. I only got one daughter. You want the cake done, or do you want the ingredients for the cake? They said, well, we want the cake done. I said, well, that'll cost you $13,500. Here's the cake. Take it with you. And it was point one. It was having it already done saved them 3 years of trying to do it. So if you leave here without the cake, I'm going to sell it to the other guy tomorrow. So that's what they bought, was the doneness of it. Nothing else.
My case was similar. I had an 82-year-old inventor who had a very good idea. It was actually for a sharpener for a knife. And he insisted on a 20-year royalty. And no family, no nothing. And you went, I said, you look good. So that's the kind of thing you've got to watch out for. You've got to be realistic. You know, you can't be crazy or greedy. You know, his 20-year royalty, he wanted to make it huge, and so he ended up with nothing. Just keep in mind, is what I said about NDAs. They may refuse to sign them. They may give you one that they want you to sign. If you have your patent filed and this is the big fish, sign it, because you're not going to get another chance. As long as your patents are filed and they're substantial enough to you, you know, you've got to be careful not to alienate them completely. Let's see. Well, one other thing that you may be able to do, and it depends on how much they want your invention. If you're looking to sell your invention, and I've had this happen twice in 15 years. If your invention's really good and they really want it, or they really think it might be good to them, you can sometimes get money to forego further marketing of your invention
Good
to other
evening.
companies
The time
while
is
they
now
evaluate.
8:45 and the library will close in 15 minutes. This is the last call to place any items you wish to check out to the circulation desk. Please begin to pack up your personal
Only
belongings
30
and
hours
exit
left.
the
You
building.
have to have me.
Thank you.
That's hurry. Anyway, sometimes you can get money for that forbearance period. You know, it's not going to be a ton, but I've had guys get $10,000, $15,000 to hold off for 10 weeks.
What about the situation where a company may want to buy a patent to preclude a competitor from getting it, even though they have no intention of using it? Have you run into that?
Yeah, I've had where they want to preclude a competitor, or they have a competing product and they don't want yours on the market. And so they buy your patent and shelve it. You know, what I run into is the pride factor.
They may not disclose that they want to shelve it during the negotiation.
Yeah, they may not, you know.
You're thinking that you want a royalty or want some payoff down the road, and they're saying, and they know they're not going to use it, so.
Well, if they're buying it, you don't care. You get your money for it anyway. You know, you may have some pride in wanting the world to see your invention. That's up to you. If you want to talk about royalties, you should always negotiate a minimum royalty. So they have to pay you a certain minimum amount every year, regardless of whether or not they sell anything. That way, if they shelve it, at least you're getting something. But you know, you don't know, and you know, my advice is if you get enough money, walk away. You know, the pride of authorship and wanting to see the world have your invention. Well, if that's that important to you, don't sell it to them. But keep in mind, you know, again, 100% of nothing is nothing.
I thought there was an issue about holding a patent to prevent being used solely for that purpose.
Not in the U.S. You can turn around and shelve it. It's not a problem. That's what they call these patent trolls. You know, they sit on patents and then they wait for somebody to infringe them. Was it the RIM BlackBerry case where the company held that patent? I think the settlement was $600 million. You know, they had no intention of ever inventing anything. They just waited. But there's nothing that prevents you in the United States from being able to buy a patent and not use it.
But if you don't use it, don't you lose the patent right?
No. There's no use requirement for a patent.
You're not required ultimately to license it in some way if it's not going to be used?
No.
Was that ever the case?
Not in this country.
But it has a shelf life about its own.
It's got 20 years from the early expiry date.
Right.
But there is a requirement for defending one's own patent rights. Is it correct?
It's not a requirement. You don't have to defend it, but you can lessen your ability to defend your patent by not doing so.
The fact that if you
And there's what's called latches. You know, if you know somebody's infringing your patent and you wait 3, 4, 5 years before you go out and sue them, you may be precluded from doing that. So you've got to be careful with that. Shall I stop?
No. You want to just wrap it up or something?
Sounds like thank you all very much.
You got 13.5 minutes.
13.5 minutes. $1 million a minute. I can keep talking. The only other thing I want to say is a lot of you may go in front of venture capitalists. You go in front of VCs, be careful. They're going to want equity in addition to paying you. They will not likely sign an NDA. They will also want to put a management team in place of you usually. A lot of inventors don't like that. A lot of inventors are notoriously bad managers, these guys that want to start a company around their patents. If a VC comes in and wants to put in management, evaluate it, if the management is talented, you're probably better off staying in the back room and continuing to invent and give them their equity stake if it's reasonable. Because again, failing to do that, 100% of nothing is still nothing. You know, and it's hard to market your invention yourself. That's all I got.
Thank you.
Thank you.